Bismillahirrahmanirrahim. First of all, I would like to thank IPS Khalid Rahman Saab for arranging this. And I understand that Justice Dr. Al Masood Saab is also present, and my personal regards to him. And actually, we are waiting to listen to him. I also had an opportunity partially to listen. I was going in and out to listen to earlier speakers, and I am really enriched by their discourse. I would like to, before coming to the subject, comment on Professor Azizur Rahman Saab and Imran Shafiq Saab, the teacher and student combination, remarkable combination, and they have come out with some excellent formulations. And I think that's an area that both of them, or at least one of them, should document. Whatever they have said is very enlightening from an academic standpoint, because what Azizur Rahman Saab said makes me very intriguing about the privatization of justice and so on. And the way he has articulated the idea, something that we sort of miss out, that how the learned judges bring in their judgments. Sometimes those international conventions and treaties that Pakistan has not yet ratified, and examine its impact and link it with the local jurisprudence. So that is an interesting point to flag. This reminded me of a scenario when I remember, I believe it was Justice Iftikhar Chaudhary's judgment, in which a convention on enforced disappearances was mentioned, while Pakistan had not ratified it. Not that one endorses by any chance any enforced disappearances. Certainly it is to be condemned. But at that point in time, I think it was 7, 8 years ago, a little more than that. I remember when this reference was made in this judgment, it was immediately picked up by the Indian side in Geneva, and this judgment was given a reference, and they relied upon it as one of their arguments. So in one sense, the courts need to appreciate that while they are independent within the state, they are not independent from the state. From international law standpoint, they are viewed as subsets of the state. They are instrumentalities of the state, and their judgments are to be seen as act of state. So all judgments that they author have an impact from an international law standpoint. So I believe that this I found to be a very interesting point from Professor Aziz's discussion. Imran Shafiq Saab is a young scholar, and I think the practitioner hat brings out in him a very remarkable academic person. I think that's a very interesting thesis, that how you can link up the Islamic law framework. The Islamization debate is a debate that I have just recently ventured into to understand far, in a way. And perhaps the audience may be aware or not. We recently, I have set up a Quran Covenant Research Center, or a center where we are doing some research to identify the covenantal framework of the Quran, and to bring it out very clearly that Quran itself can serve as a covenant. It has an identity of a covenant between Allah in each one of us, and there is a covenant, and then number of covenants in the Quran, and a publication has already come out, which has been published by Sangemil. It was inaugurated at IPS, so I'm grateful for that as well. And Professor Khalid Masood Saab has been very kind to encourage that work. There are covenantal framework within the Quran, and then there are covenants under the Quran, pursuant to the Quran. And these covenants are of three categories. The category one are the private contracts that everyone does in everyday life, whether contract of purchase of land, commercial agreements, shipping bills, any other contract which is of a private international law or contract law nature, is a contract within the definition of misak and the word akud that occurs in the Quran, and the Quran tells us that we have to honor every agreement that we enter into. So that's one category, that private contracts have to be upheld. The second category of MISAC are the international treaties and conventions. So they also fall in the definition of MISAC. And by virtue of that, they need to be upheld by a believer state or a Muslim state who believe that they have to honor their international commitments. And the third category of covenant under the Quran or Misak under the Quran are the laws of the land. So every law is essentially a contract between the state and an individual. The political scientists do call it social contract. So that also falls in the definition of, I would say, Misak and Akud. And unless, of course, there is a very specific provision or specific law that is contrary to the injunctions of Islam, that one needs to step aside and maybe avoid mischief of its implementation, particularly when one is in a foreign jurisdiction. But and a list of certain laws that were identified by those judgments in which certain provisions of numerous laws have been declared to be contrary to Islamic injunctions, they are still on the statute book. So minus those, the remaining bulk of the domestic legislation of about, I guess, 8,000 federal laws and 3,000 each provincial laws are MISAC, and they can be or they should be upheld and honored by the citizens. And this aspect needs to internalize by perhaps ulama, scholars, and people like us to the people that most of the laws that exist in this country are in conformity with Quran and Sunnah of the Prophet, peace be upon him. This point needs to be driven home. My team has worked on a very interesting article in which we are arguing that what was yesterday called a sin or guna is today called offenses in most of the cases. So Pakistan Penal Code 400, 500 offenses are in fact articulation of what was being told to us since childhood, that these are the burais, these are the guna, these are the khata that you should be avoiding. So if you are able to relate an existing law with an Islamic framework, then the compliance can become voluntary. If you are able to relate industrial relations ordinance, that payment of wages in time, for example, with the Islamic fiqh, with the Islamic jurisprudence, then there will be a conscious effort to comply with it voluntarily. And likewise, if it can also sink in the ILO convention, so you have the domestic law, the international law, and the divine law all in line, and you have this inherent clarity that while you are complying with apparently a domestic regulator, whether it's an inspector who is coming to your factory, or inspector who is looking at weights and measures, or an inspector who is trying to look at under the food law what is that we are doing, it is not merely a compliance with the provincial statutes, not merely compliance with the federal or international law, it's also compliance with the larger link that you have with the framework of the Quran itself. And I remember a lot of scholars have been talking about it, that if somehow people could have this feeling and this sense that law of the land is in sync with what they believe as in religion and what they believe socially, then the compliance will become voluntary. Then the entire effort of the state to make people force the compliance can also be spared, or at least it can certainly lessen the pressure on its own resources. The other interesting point, I think, which came up for discussion was about about incorporating mediation and other privatization of justice. I thought that was very interesting. So privatization of justice is an interesting thought, but we have ADRC and other frameworks, and I believe there is a covenant with the mediators to resolve issues and make a proactive effort. So perhaps that may be taken in that context. I remember giving this presentation partially in Riyadh International Week of Arbitration, where this discussion had come up. And again, to help lessen the burden of the court work, it was thought that this is an option that could be looked into. The significance of realization that you are bound by a framework in current scenario is difficult to sell globally at the moment, given what Iran and what Israel and what particularly United States behavior towards international law is. But nevertheless, I found it very interesting that Khamenei's fatwa against the use of nuclear weapons was a very, very interesting thing. And I explored a little bit more on that to figure out that what is the nature of that legal document that was issued by the Khamenei's office. And it turns out that it was not only relied upon heavily, but it was also mentioned very periodically in the UN debates as a position by government of Iran before the United Nations and so on. So it is very interesting that the government of Iran feels bound by the legal framework of Islamic jurisprudence more than it considers bound by the NPT itself. And if you notice in a very interesting development, they're trying to unwind it before they consider withdrawing from the NPT and serve a notice for the withdrawal from the NPT. So again, emphasizing the point that if people of a certain country who believe in a certain religion can associate the law of the land with that religion, with that sense of faith, then they will want to comply as a matter of personal religious obligation as well. So Islamization, more than I would give another term, I would say recognizing existing laws being in conformity with Islam. So one approach is you could make an effort, a very extensive effort to recodify every statute, every convention, and every rules and regulations, which is going to be uphill task. And codification, as we all know, has been attempted quite a few times in select areas, but people have come down again to the basic existing commercial framework. It might become over a period of time difficult. It can be attempted, but the procedural laws like motor vehicle ordinance, for example, like marine shipping laws, like transfer of property laws, like sales of goods, international laws and conventions, to identify and to make an effort to recodify them, except in the zone of Islamic financing areas, may become difficult. So one approach is to identify very clearly that these laws are consistent with Quran and Sunnah of the Prophet, and therefore we can associate our mental intent or consideration as being linking them up with a Quranic framework at the same time. Allah has been sending messages not only to us, but to nations earlier to us, and most of they have, they've passed on sense of right and wrong to the entire humanity, by and large, to entire human race, which is now divided into states and various nations. And if you look at the common zone of sense of right and wrong, it is by and large identical. Leave aside a few controversial areas like LGRB2. But if you pick up international conventions on crimes, international conventions, let's say all countries criminalize the wildlife trade. It's a crime. So there's a consensus amongst 157 states that this is a global crime. There is a crime agreed by everyone under a UN Convention on Corruption, that these 4 crimes which are listed, or 25 crimes which have been listed in the UN Convention, and they are, if you make an effort to link them with Quran, you will find them very interestingly, they are linkable. Similarly, international convention relating to terrorism, international conventions relating to trans-organized crime, they all identify, they all legislate an inherent sense of right and wrong that was gifted to the human race. And over a period of time, it has been re-articulated. And now you see a convergence of that through international treaties and conventions, because once you agree, 150, 190, 180 countries signed a certain convention and say to us, this is a wrong. We will take action against it if anyone conducts it. So there is legislation and unanimity on that, and it is linkable very conveniently to the Islamic jurisprudence itself. Thank you.